Good morning and welcome to the David and David on Real Estate podcast. Today we are in episode number 159. David Korman, so glad to be co-hosting with you again. Welcome and thanks for joining us this morning.
Always a pleasure, David. And today for this segment, we get to talk a little bit about some legal issues, legal cases that have come up, and so it's always interesting to see what the courts are doing, especially in a market like we're in right now, where where it's a tougher market, harder to get transactions done, harder to get them closed. And then what happens in certain situations, things don't close, and then obviously it goes to the courts. And I hate when things goes to the courts to get resolved. I'm always looking for a way to get transactions closed, and like going through the court process is never good for anybody. There's other than the litigation lawyers, and I don't like take money out of their hands. But if we can avoid it and keep it in the hands of the buyers and the sellers, I think that's our collective duty as real estate agents, as real estate lawyers. But I know you love this stuff, David. You like talking about cases.
I do. I love contract law, and it's great to see some of these. I mean, I agree with you that going to through the court system is never fun, but it reinforces a lot of the key concepts that we keep talking about, right? And I mean, I came across this court case in the real estate magazine the other week, and they did a great job sort of summarizing it. But I thought we can, peel back a little bit of the layers and sort of jump in a little bit more because you and I have been talking about this for 159 episodes. What happens when there's a breach of contract? What happens, when the contract is not accepted in the right irrevocable period? What constitutes a counter offer? So there's a lot of things at play here, and I think it kind of summarizes and puts everything together. This one case that we're going to talk about, a lot of the different legal issues that we keep talking about, throughout these 159 episodes. So you know me really well. I got really excited. I'm like, I got to bring this to David Corman, and let's have a discussion on this.
Yeah, so the case we want to talk about today is a case called Ali versus Patel, and it's pretty basic, simple facts. And I'll summarize what they are, and you'll see. Like, I'm sort of surprised this even ends up in court because it's I think it just reinforces what we think the law is and what we've always thought the law is. So there's nothing I don't think really new here. But what happens is, an offer is presented. Buyer presents an unconditional offer, irrevocable, till the end of the next day. And there's a Schedule A attached to it. And when it gets signed back by the seller says, sort of accepts everything, but says, oh, by the way, here's a Schedule B that wasn't included with the offer signed by the buyer. And and then now the buyer never signs the Schedule B, and the seller takes position they had an agreed upon offer because the original contract was signed with just the Schedule A, and the buyer says, no, I'm not closing, because we never signed the final form of agreement. And anyways, the seller has to resell the property. It's sold a week later for 25,000 of shortfall, so they sue that buyer, saying you breached the contract. We had a binding agreement of purchase and sale. So that's sort of the facts. And to me, it's like, no, it's to me, it's so simple because we've been talking about this, like you said, Dave, for 158 episodes already, that anytime you sign an agreement for purchase sale, there has to be a meeting of the minds. The buyer and the seller have to sign the exact same agreement. And this is an example where it wasn't, oh, they changed, one date, or they changed a number and it wasn't initialed. Like, usually that's enough. If they don't sign an initial every single change, the law is you do not have a binding agreement purchase and sale because they didn't accept every single change that was done. Here it was a whole Schedule B that was missing. So the seller never accepted the same offer that was presented. Like, the seller could have said, I'll accept this offer the way it was written with the Schedule A, with nothing else. And they would have had a binding agreement of purchase and sale. And unfortunately, it's missing stuff that sort of both parties wanted in Schedule B. But if it wasn't there and they accepted it, then that would be enforceable. right?
Yeah, and I think the judge actually, said that in his findings. He said, if the Schedule B wasn't attached back in by the seller, then you would have had a firm binding offer. But because the
Right.
offer was accepted, and then the seller said, "Hey, I forgot to attach the Schedule B. By the way, initial this," right? And it goes back to the whole concept of having clean hands, right?
Yeah.
If this transaction came to fruition and the buyer actually closed, there would be no issues with this because both parties would kind of look at this and say, okay, we're moving forward. But
Right.
because there's a technicality on the line here, and it's a pretty big technicality, the buyer exploited it and used it to their advantage and used it as a crux not to close on the transaction. But I think it really illustrates the point of counter offers, irrevocabilities, and having that meeting of the mind and making sure that um, realtors, make sure that the paperwork is done properly. And David, the reason why I chose this particular situation is because I see realtors doing this all the time. Oh, I forgot Schedule B. Well, technically, if you forgot Schedule B, leave the offer as it is. Get an amendment done and say,
Right.
hey, we're going to be, changing the schedules on the APS, and I'm attaching a Schedule B through an amendment. That way, the offer is still firm and binding, and
Right.
now you're talking about an amendment, right?
Right.
And if the buyer refuses to sign the amendment, well, you still have a firm and binding offer. Yes, you're missing some of those details about business days and whatnot, but you still have a firm and binding offer. If you attach it to the original offer after you sign the confirmation of acceptance and expect the buyer to initial, well, you're creating a situation where now the courts have ruled that there was no meeting of the minds. You had no offer.
Yeah, exactly. And maybe we should just explain what the Schedule B content sort of is here. And it's a little bit different with every brokerage, but every brokerage sort of uses a form of Schedule B that's sort of neutral. It's not something, there's no deal breaking things in Schedule B. It's just covering things like a definition of what a banking day is. So you can calculate the days properly without dispute, procedures if the registry office is closed on the day of closing, how you deal with closing the next day, holding deposits, key information, things like that. It's like none of those issues are generally deal breakers, but they're good for both sides, usually to have those provisions in an agreement of purchase and sale. So in this fact situation, if that Schedule B would have been attached from day one in the initial offer presented by the buyer, the seller would have accepted, the buyer wouldn't have had a problem with anything since in Schedule B. The seller would have accepted Schedule B, and there never would have been an issue. So the fact that it was left out, though, this opened up an out for the buyer to get cold feet and change their mind. Okay. And it should have been handled exactly the way you suggested, David. The seller should have just said, okay, I'm signing it. We're accepting. We got a binding agreement. Signing it exactly back the way the offer was presented. So, and it's done by the irrevocable time and date. Then you got a binding agreement. And now the seller can say, oh, by the way, we forgot to attach this Schedule B. It's good for both sides to have this Schedule B. Let's do an amendment to add this Schedule B to it. And if the buyer says, no, I don't want to sign it, so be it. They've still got an agreement and they can still move forward. And if they get into a dispute over calculating banking days or number of days, there's other ways to deal with that. Okay. If they get in dispute over the whatever else was in there, when how the keys or the lockbox is going to be, you can deal with that because you still got a binding agreement of purchase and sale. So you're 100% right, David. That's the way it should have been dealt with. But this, by virtue of the fact that they've signed it back by adding the Schedule B to it, now the buyer has to accept that Schedule B, or the buyer has the right to get out of the deal.
Right. So the other thing they could have done is they could have changed their revocability from buyer to back to seller, attach the Schedule B, and then let the buyer execute the offer with all changes, including the other schedule. Right. So there's a number of different ways, but there's no shortcuts. That's the biggest thing we want to press upon you is if you, if you approach the situation from taking a shortcut and wanting to, look good in front of your clients, or bend the rules, or get to that hockey game with your buddies and not do this paperwork properly, it will come and bite you in the butt. And you are going to be responsible, and you're going to put your clients and yourself in a really uncomfortable situation. Like David, this buyer and the seller, how much would they have spent on legal fees? How much years, how much time, how much effort, how much energy, right? All because of a technicality that, the realtor unfortunately was at fault for.
Right. Yeah, and I think in this case, the buyer said, I'm withdrawing my offer, and by the way, I never made a deposit anyways, so I'm not going to make a deposit. So there wasn't any money there. But what all of this case really does, I think, is reinforce what we understood the law to be. It didn't create new law. Okay, it just gave a great example, which is why I said at the outset, I'm sort of surprised this ended up going all the way to a decision in the court, because usually, the advice that any lawyer would have given to the seller here is you got no chance of winning here based on these facts. So I'm assuming they got that advice at some point. So maybe they were just trying to push this to the end, thinking that they might get the buyer to pay something as a settlement, even if the buyer's not likely to be found. Sometimes instead of going through the whole court process, a buyer might say, you know what, I'll give you something for your just to settle this thing. But other than that, I'm sort of surprised this went all the way down to a decision. But but it did, so it reinforces the idea that that you have to get every single change that's made in an offer. As soon as one item is changed, someone submits an offer with an irrevocable date. As soon as the seller makes one change to it, doesn't matter if it's the closing date, the amount of the deposit, the purchase price, the irrevocable date, anything that's changed and initialed. As soon as they make one change, it now becomes a seller's offer that goes back to the buyer. And now the buyer has to accept any changes that were made by the seller. And if they don't, there's no offer. The seller can't say, oh, you're not going to accept that change? Okay, forget it. I'm going to accept the offer the way you originally presented it. It becomes a seller's offer. And that's what happened here. Seller added Schedule B, it becomes a seller's offer, and then it's up to the buyer to accept it or not. And it gives the buyer an out. So no agent out there should think otherwise. Okay. Everything has to be agreed upon. Every detail has to be initialed. Every change has to be initialed by both parties in order for it to be binding. They have to agree to the exact same terms of the agreement, which is what the courts refer to as a meeting of the minds. You have to have a meeting of the minds. So the evidence of the meeting of the minds is that they've signed and initialed everything exactly the same on both sides.
100%. David, let me throw a little curveball into this situation. So now that there's this court ruling, and now that there's a clear indication that the realtor has erred in how they presented this offer, and there are damages here that the seller has encountered, would the seller now be able to go after the realtor through an errors and omissions claim on their insurance? Because now there is a court ruling saying, hey, listen, there was some technicalities in this offer and the realtor did it. Would the seller be able to turn around and sue their listing agent now?
Yeah, I'll never want to give a clear black and white answer on something like that, but there is definitely the potential, depending on what the communication was between the seller and the seller's agent at the time, because the seller's agent should be explaining the situation to the seller, saying, "Hey, look, we signed this agreement. We should have had Schedule B attached. I forgot to do it. It should be in there. This is what Schedule B. Explain what it is." The buyer's agent probably should have pointed it out as well, because it's good for the buyer's side too to have the Schedule B in there. But neither of us did it. So now we're at the place where it'd be good to get Schedule B attached. So if we sign it back with Schedule B, we're opening it up to the buyer to get out of the deal. And if we don't put Schedule B, then you can accept it as it is, and then we can deal with the terms that are in Schedule B afterwards and try and get an amendment, and they may or may not sign it. If they sign it, great. If they don't sign it, here's the way we can get around it. But you really, if the seller's agent has to have that whole conversation and explanation to the seller, and if they didn't, and it was the seller just trying to cover his tracks, afterwards, and never explain it because now that if they never explain it, then the seller never got the option to instruct the agent which way they want to proceed. No, let's just accept the offer and take our chance. Now I got a binding agreement. We're going to close. I know we can work out what banking days are and things like that. But at least I got a binding agreement. And if they don't want to sign a Schedule B, we can still close. So I'd rather choose that as opposed to opening this up as a sign back. Or the seller could choose the sign back. So if the seller is making the choice which way to go, the seller's agent's not going to be liable for it. Okay, because I don't think they'd be liable because they disclosed it and they said here, here's the situation. Now, because now the seller is choosing which way to go. So they're accepting what the potential outcomes are of that. Okay. Now, could a seller still make a case? Well, you put me in a pickle because you forgot Schedule B in the first place. So I don't like either of these options. So if we can't resolve this nicely and get the cooperation of the buyer, agent, I'm coming after you if I suffer any damages. And depending on the fact situation and what was actually explained, there is that potential that the agent could be exposed to a claim from their own client.
Right. And David, you mentioned something that, I spent some time thinking about and really resonated with me. And I think that we see this a lot in the legal profession where you guys actually take instructions from your clients and explain the different, outcomes. I think we need to see that more in the real estate profession, right? Like in the real estate profession, we're much more inclined to say, hey, this is how we do it, and this is how the law works. So let's just follow that process. But I think a lot, the really good agents will give different scenarios to their clients, explain the different scenarios, and then ask their clients for instructions on how they want to proceed. And that really takes the liability off the shoulders of the realtor. As long as you're involving your team, right? So as long as you're involving the lawyer, the accountant, all the other professionals, and you have a really good team and you're giving really good advice to your client, and then you're waiting for the instructions of that client on how to proceed. I think it's an excellent topic, and I think it's something that our industry needs to do a much better job of sort of really paying attention to, because realtors all too often are led down this path of, hey, this is how it works, this is how we do it, let's just do it this way, right? But they don't really stop and don't really get instructions from each individual clients all too often, which is something that lawyers in your profession does really, really well. This is the law, but I'm still waiting for your instructions on how to proceed.
Right. And the key otherwise to that, David, not only do you have to give the explanations to your client, but you have to have evidence that you did it. You have to keep some notes. You have to confirm things back to them with an email, with a text, or something in writing, because that's going to be your evidence if it comes down to at the end of the day that you did give them that advice and they did make an informed decision and they had options and it was explained to them. Because in the absence of that, they come after you. It's your word against your client's word, and they're making a complaint through RICO or something against you too, or in the courts for damages, and you got no evidence to support the fact that no, you had all these discussions with them. They chose to go this way. Then you're just going to be screwed. And you can take the same fact scenario another way. Deal falls apart. Buyer doesn't want to close on the same facts. They put it back in the market and they sell for $25,000 more. Now you're a hero, and your client loves you. And the last thing, oh, that worked out so good, but that same client would turn on you in a second if they're losing $25,000, right?
1000%.
So don't put yourself in that position. First of all, make sure you put your Schedule B in. Like that's the first thing. But if something happens, you got to make sure that an agreement is signed, whether it's Schedule B or whether it's any other change to an agreement. You got to make sure everything is signed and initialed properly and you have a binding agreement. In the absence of that, you make sure you've explained everything to the client and have, making one little change opens up the transaction to the other side because you got to throw it back.
Yeah. Be a professional, don't cut any corners, explain everything, and follow the lawful instructions of your clients, and you'll be just fine. That's simple.
Yep.
David, always a lot of fun discussing these with you because I think they put into context kind of everything that we talk about, and they really exemplify, how the law is sort of applied. Nothing new here, but again, it's a great case to sort of dissect and analyze and really dive into. And as a broker owner, I see this happening all the time. I see that it's 11 p.m. at night, and
Mhm.
it's been a 2-day negotiation, and you're in that final stretch, and oh my God, we're here, but oh my God, I forgot this and I don't want to go back and I don't want to look bad. Well, you know what? We're all human. It's a lot easier to go back and say, hey, listen, I forgot a schedule B. This is how we're going to fix it. This is what's going to happen. Than it is getting to the finish line and now having a situation where buyer chooses not to close and you're actually part of that issue because you've erred and you tried to cover up your tracks. So don't put
Right.
yourself in that situation. Don't put your clients in that situations, and don't cut any corners.
Yeah, and I think just the last point I want to make on this, David, is we went through a period of time. There's a whole bunch of real estate agents that sort of grew up in the last 5, 10 years when the market was active and good, and they were cutting their teeth in a market where there was multi-offer bids. And if a deal fell apart, it wasn't as big a deal because the prices were still going up and there was other buyers available to scoop up the property at the same purchase price or a higher purchase price. So we're in a different market. So people got a little bit lazy and careless because of that. Because if a deal did fall apart in this situation, well, there was 10 offers. So if this offer fell through, we go by, we got 9 other people we're going to go back to and we're going to sell it and still get that purchase price. They weren't as exposed. But those days are gone. We're in a tougher market right now. And if things have to go back on the market, it's really easy to see a $25,000 reduction in a purchase price, depending on when it goes back to the market. And there wasn't a lineup and multi offers. So we're in a different market. So you've got to make sure you do all you're crossing your I's and or dotting your I's and crossing your T's and making sure everything is initialed and done properly. Okay. Because there is a risk of damages in the current market.
100%, 100%. And everybody has to just be a little bit more due diligence. Not that, there was any excuses before, but everybody has to be a little bit more due diligent.
Yeah.
And look, we want to hear from you. Tell us your story. Share your stories with us. Send David Korman, send myself an email, share your experiences, and we'd love to weigh in on some of your situations. So thank you everybody for tuning in, and we'll see you guys on the next episode of the David and David on Real Estate.
Thanks, David. This was great.
Absolutely.